Thank you very much. Well, the text of the schedule has nothing following this until 7 o'clock. So I could take a very permissive interpretation of the schedule as allowing me to speak until 7 p.m. But I think we can all agree that would offend the principle against absurdity in interpretation. So I will try to be quicker than that. But the role that was assigned to me, I'm pretty sure in my absence, I'm not sure that I ever agreed to do this, was somehow to wrap up the extremely rich conversations that we've had over the last day and a half, and to draw out some common themes in relation to implementation, which for this particular conference happens to have concentrated quite largely or quite heavily on the role of courts, although we saw also mentions of other things like parliamentary committees, focal points, and so on. But I think given the content of the conference, we might think largely here about the role of courts and the broader issues that that gives rise to. And so in that respect, I have 7 observations on what we have been talking about for the last day and a half, and I will try to communicate them all within 10 to 12 minutes. So the first, and I guess these are common themes, I'm going to kind of just raise questions. I don't propose to answer anything, and I don't propose that we would then go on to try and answer anything in the interest of getting home. So the first is a set of questions or a set of observations around legal cultures and legal culture. We spoke about it largely in terms of the contracting states. So from our very first session yesterday, there was discussion about formalism and excessive formalism in the application of rules, and about the fact that a body of law and a system of case law which requires a kind of principled and substantive engagement with interpretation and with the reasoning of a set of cases, as the Convention case law does, may well pose a significant challenge in systems that are transitioning from hyper-formalistic approaches to adjudication into a different form of legal analysis and application. And I think this was raised particularly well yesterday in relation to Ukraine, when you were talking about experiences in lower courts there. And of course, in some ways that relates, secondly, also in terms of legal culture, to expectations of decision making in judicial bodies. So different contracting states and lawyers and courts in different contracting states will have different expectations of what a judgment should do, should be, should provide in terms of not only clarity for remedy, and Vasilis mentioned this, like sometimes it's not always clear what the remedy would be, but also in terms of the usability of that judgment going forward. So something that we might vaguely call precedent if you came from a common law background. So just 2 illustrations from our conversations of ways in which these questions about legal culture seem to me to be relevant to our discussions about the implementation of the Convention. They relate to my second point, which is a much larger body of analysis, and I won't go into all of it, but it's something that I think ran through quite a lot of our discussions, and it's about constitutional maturity, which is not necessarily the same as constitutional age, although sometimes they might be aligned. So in, let's say, we spoke about it earlier, as did you in terms of Croatia, in a transitional state, courts may be given explicitly or implicitly a role in helping through constitutional interpretation to transform that state into a new mode of governance. And in those kinds of systems where there is a combination of a transformative agenda, judicial self-confidence, and a robust independence principle for the judiciary, domestic courts may well be able to take Convention jurisprudence and use it to truly harmonise their constitutional principles. I think we saw many illustrations of that. So there probably is some kind of alignment in terms of constitutional age, maturity and implementation when we're thinking about perhaps so-called newer constitutional settlements. But it also arises in terms of older, in terms of older constitutional settlements. So in Germany, in Ireland, in the UK, for a long time, the view was we don't need to use convention jurisprudence or the convention per se in constitutional adjudication because we have a perfectly robust, well-developed system of constitutional rights protection that is as good, if not better, than the rights protection provided in the convention. And I mention this not only because it is in some ways an interesting point, but also one that might not raise terrible issues of implementation. So if your domestic legal system really did align well with the convention, we wouldn't be particularly worried. But even older and more mature constitutional systems will sometimes suffer ruptures in their constitutional settlement. And that, in my view, is precisely what the fuss in the UK is really about now. It is a set of constitutional growing pains where a very old constitutional system experiences a shock to its system through a combination in the UK, for example, of the Human Rights Act, which radically changes the role of courts, combined with the creation of a new Supreme Court, combined with devolution settlements for Scotland, Northern Ireland and Wales. And so perhaps it is to be expected that in some ways we have now a fairly new or immature constitutional settlement in the UK to which the institutions of the state have not yet caught up. So if we had a formal system of a brand new whole constitution, we might have had a discussion about the fact that we would expect apex courts to be transformative, imaginative, evolutionary and so on. But we didn't have that kind of conversation because I'm not sure I'm not even British, sorry, I'm not sure the UK really even realised how radical the set of constitutional transformations it was undertaking was going to go on to be. So that then relates to the third thing that I think we saw coming across throughout our discussions, and that's about constitutional culture, which we might broadly, I don't even know if that's a phrase, but let's just use this idea of constitutional culture to think about a couple of things. One is judicial independence, which is clearly vital at domestic level for courts to be able to take some risks and exercise imagination in the way that they think about the relationship between domestic law and the convention. And that, as we heard in relation to Croatia this morning, requires a culture of trust in the institutions in question. We don't necessarily, so I guess in Germany maybe we have trusted both sets of institutions, national and transnational. In the UK, we seem to trust national, but not the international institutions. And from the sound of Croatia, you trust the international, but not the national. But we have to trust somebody, right, who is the judicial body, in order to be able to capitalise on judicial independence and take these risks. And that relates in some ways then to what the President talked about in his opening keynote yesterday, openness to internationalism. In the constitutional structure and system, and that, of course, relates to constitutional identity. We've used the phrase, or some have used the phrase, constitutional identity as if it were somehow a dirty word, or somehow a negative thing for a state to have a constitutional identity, but it is in the essence of constitutional states that they would have a constitutional identity. Indeed, it is often laid out within the constitutional text itself, either in a non-binding preamble or in binding parts of the constitution. So Germany's commitment to social responsibility is part of Germany's constitutional identity. Ireland's commitment to a united Ireland is part of Ireland's constitutional identity. There is not necessarily anything wrong or incompatible with Europeanism, let's say, from having a constitutional identity. And I think that's just a really big can of worms that we have to think about. Not only is it relevant, but also how might Strasbourg be said to have made constitutional identity something that states can use to try to leverage exceptionality from what we might expect from the convention. So if Strasbourg were to say, for example, that protection of fetal life is part of the constitutional identity of Ireland, which it effectively did, then it allows Ireland to have a wholly exceptional position, almost globally, in relation to its restrictiveness in terms of abortion. So there's a little bit going both ways there in thinking about that. And the final point on constitutional culture, which I think came up repeatedly, is about the interaction of constitutional actors within the contracting party in question. So is it the convention within your constitutional system for courts to hold back and allow Parliament to take the lead, or allow politics to take the lead in making major changes and major decisions about legal arrangements, particularly, let's say, where compliance with the convention might require constitutional change. So you have every extreme from a court that will take the Russian Constitutional Court's approach to a court like Ireland's or the UK's courts, which might suggest to Parliament that they really ought to think about changing the constitution, to a court like the Lithuanian Constitutional Court, which, if I understood this correctly, can actually order constitutional change in situations of incompatibility. I may have misunderstood that, but that's correct, right? So you see massive variation in the relationship between constitution actors, which surely is significant, I think, when we're thinking about implementation. That takes me to the fourth point, which I don't intend to go into because we have talked about it quite a lot, and it is political culture and the political climate within a state. I think that it ranges, of course, from anti-internationalism and sovereigntism to some kind of reluctance to engage in societal change that the state is not yet, or does not consider itself yet, to be ready for. And that is, I just want to say one thing about that. Sometimes the political culture will be reluctant to concede to any socially unpopular change because it is so costly in domestic political terms to do something that the people don't want. And actually Strasbourg can really help there. Because if Strasbourg says X change is necessary for convention compatibility to be achieved, a government that does not officially want to do this thing because they don't want the cost can say, look, I'm very sorry, people, but we have to do this. And the convention, the judgment from Strasbourg can really assist with that. It has risks because then you set up a bogeyman in Strasbourg, which actually is exactly also what's been happening in the UK. You set up a bogeyman. But it's nevertheless an interesting set of questions that I think we have to think about. And it brings me to the fifth common theme across our discussions, which it strikes me is a really immediate and important one. And that is that there are real questions of values and of variations in values across what we now call Europe when we think about the European Convention on Human Rights and the Council of Europe. These are not only what we might call social. For example, should you be able to keep your maiden name, your name, when you get married, or should you be able to marry if your partner is of the same sex? Also societal. So should there be some kind of expectation of social assistance from the state? And these are not always clear-cut. And this is really tricky. For people who believe in the convention, it's very tricky because instinctively I think we all have to accept that there are some social and societal issues that are contestable, where you can have reasonable disagreement between reasonable people as to what is appropriate, what human rights law might demand. And what's difficult for the court here is that the system puts the court in a position where it almost has to pretend to a certainty that doesn't exist about the right answer. There is not always a right answer. And it is also true that the right answer might not be the same in Vienna and in Vilnius. So, but how does I don't know the answer to any of these questions, by the way. How does a supranational subsidiary court, like the European Court of Human Rights, navigate those waters while still retaining the faith of the people who believe that the court is the only way that they will get vindication of their rights? And that seems to me also to be something that somebody much more equipped than me is going to have to figure out. So then the sixth point is about the court itself. I actually am not going to say anything about that now because Judge Yudkivska has dealt with it completely in her concluding keynote as well. The tools that the court has to try to manage these tensions that we've been talking about. And so it brings me to the last point, which was also prompted for me by something that Judge Yudkivska said earlier and again in your closing keynote. And that is that somehow, to me, one of the big challenges of implementation is actually the need to grapple with the big question of purpose. What is the European Court of Human Rights for? What is the European Convention on Human Rights for? The preamble might tell us it is for the pursuit of a common endeavour in which, as you said earlier, jurisprudential development is the shared work of both the national and the domestic courts, as well as the political systems, again, at both supranational and domestic levels. But does everybody really believe this? And in particular, does everybody believe that this is a project that matters for them now? That this is a project that is relevant to the situation in their countries? And maybe this is the real level on which the regional challenge or sub-regional challenge exists. Because even though it would be a terrible thing for the UK to leave the European Convention on Human Rights, and Maris is going to start shaking her head when I say this, it would not result in the descent into a rights-free, totalitarian, unpredictable legal system where we were ruled by whim in the United Kingdom. That would not happen. Nobody believes, apart from Maris Amos, nobody believes really that would happen. And so so when we think about the levers that the court has to try to achieve implementation, and when we think, as you said, about the cost of compliance, we have to, I think, remember that cost is a relative concept. There is the cost of non-compliance in relation to something that people believe their own domestic legal system has settled in a perfectly reasonable, democratic, and generally rights-respecting way, like prisoners' votes, will not be or may not be the same in one country as in the other. And so somehow we have to think about how we articulate a purpose, a common purpose, for the Convention and the Court that makes sense in a time when a lot of polities in what we might call Western stroke old Europe simply do not still believe in the principle of European solidarity. Or if they do, they don't recognize the Europe for whatever complex and often unsavory reasons. They don't often recognize what we call Europe in this room as a Europe with which they have or should have solidarity. And so we somehow have to articulate intellectually sound arguments that make as much sense in London as in Ljubljana, in Berlin as in Baku, in Helsinki as in Izmir. Otherwise, how do we convince everybody that the cost of complying with the judgment of a supranational court that is binding in international but not in national law is in fact worth it, even if we don't like the judgment, and even if the value is not necessarily to us but to a broader European enterprise? And if we could figure that out over dinner, I think that would be a marvellous outcome to our 2 days here. So let me finish by, can I just thank the sponsors? Yes. Yeah, so finally I have to thank, on behalf of all of us, the 3 organisations that supported us so well in organising this, I was going to say convention, but it's not, it's conference. The Council of Europe, the Constitutional Court of the Republic of Lithuania, and the European Humanities University. So thank you very much.
Well, let me also thank our speakers for the final session. This was an extremely thoughtful session with a lot of questions posed on this side, but answers perhaps came on from the other side. And I'd like to think that you thought I was an excellent chair because we're 40 minutes delayed according to the program. I haven't done so badly, I think, right? Well, thank you, and I'd like to thank the Constitutional Court as well for having us at this wonderful location for today as well. Thank you very much.
Thank you.
Thank you.